May it please the court, I'd like to reserve 5 minutes from.
All right, 5 minutes it is. Whenever you're ready.
Thank you, sir. May it please the court, Richard McRae here on behalf of the Appellant University of South Florida Board of Trustees. With me is my co-counsel, Kenny Page. We respectfully submit that the trial court erred in granting class certification in this case, essentially for 2 reasons that have a number of different ramifications. But the trial court certified a class in this case of all students who paid student fees for 4 semesters. The problem with this case is determining which students paid fees. Both parties introduced during the evidentiary hearing account details, a USF document pertaining to the plaintiff, Ms. Moore. And that document provides some detail about the fees that were charged and the fees that were paid, but not all the information required to show the source of the payment.
Does that matter though? I mean, the student's ultimately liable for it. Who paid it is, I mean, there's no contractual, for example, there's no contractual obligation of a student's parent to pay USF. It's the student who's on the hook to pay it.
Well, we contend it does matter because of the fact that the person who is suing, including all the class members, have to meet the essential elements of a claim for breach of contract, and damages is such an element.
I mean, there's no question that damages got to be an issue in contract, but you know as well as I know, there are cases around the country, the majority of which have taken the position that it doesn't matter who pays, it matters who's legally obligated. Little, I think, is the lead case in that group.
I don't agree with that, Judge, because the lead case
that's why you're here to tell us.
is a 10th Circuit case in Evans. Little is an unreported district court decision. And so I wouldn't call Little the lead case, and in fact, a couple of cases following Little have deviated from it. But the interesting thing, and in Evans, by the way, the 10th Circuit stated that the plaintiff is the master of class definition. And if you look at these cases, people propose different class definitions. Some they propose all persons who paid or on whose behalf student fees were paid. In this case, Ms. Moore proposed a definition, and the trial court approved a definition of students who paid. They could have chosen to include a class definition that expanded to a situation where there were third-party payers, including parents. They did not. So the question in this case is whether or not the class definition that they proposed and the trial court adopted is legally sufficient under the rule, under the class action rule, 1.220. And the other comment, Judge, is that if you agree with the premise that the class that is certified is not all students who had their fees paid, but all students who paid, which is what the order says, then you need to determine which of these students paid their fees. And the account details don't show that in all cases. That's the testimony. And
yeah, I think you're putting a lot of emphasis on this linguistic dichotomy that you're trying to advance, and I'm not so sure that I see there being a major difference. You know, whether they paid or whether the fees were paid, I'm having a hard time seeing that as a big issue.
The other point I would make, Judge, is that the cases, and frankly, we introduced discussion of the cases in our initial brief, but all of those cases around the country deal with the issue of constitutional standing. They don't deal with the issue of whether or not damages are an essential element of a breach of contract claim. Now, standing is related to damages, but the cases, including the Metzner case, says that constitutional standing means you suffer some injury in fact. It's not exactly the same as damages. You may have been denied using the gym at USF. That doesn't mean that you could make a damages claim. So the cases that we've been arguing back and forth over, whether or not a parent has standing or only people who actually paid have standing, are standing cases under Article 3 of the Federal Constitution, U.S. Constitution. They're not breach of contract cases, and none of them deal with the situation where a class member cannot make a viable claim because they can't show that they incurred any damages. Anyway, hopefully I didn't run off there, but I wanted to address your question. So anyway, we have what the trial court said for each fall and spring semester was between 40 and 48,000 students.
Well, I have the number 50,927. Is that?
I think that was our number on page 6 of the order granting
That's
classification.
4 semesters, but there's going to be a lot of overlap.
Some overlap for sure.
I would imagine a lot of overlap, right? I mean, we don't know, I guess.
I don't know the total number,
Okay.
but the trial court's order granting class certification states at page 6, for the summer semester it's 31,000, and for the fall and spring it ranges from 40.
But the alternative to a class action is there's going to be thousands, tens of thousands of individual lawsuits.
Correct. And we maintain by certifying the class, USF cannot prove that some of these people do not have viable claims because they cannot show damages. The people who have damages are students who paid their own fees, and in many instances, students take out student loans that they're obligated to repay. Admittedly, those people would be able to prove damages.
So if I hear you correctly, it seems like your position is it's not that this shouldn't necessarily be a class action. It's just that they have described the class wrongfully.
Correct.
Yeah.
They proposed the class, and that's what the trial court, students who paid. And as you look at that, you can't square it with the requirements of the rule. You can't square it with the fact that USF has to be able to, as a matter of substantive due process, prove that in individual cases people didn't have any damages and therefore don't have a viable claim.
So when you're focusing on damages on the monetary, so the fact that they paid fees and didn't receive anything, that you're saying that doesn't matter, it's the amount that matters.
No, I think the case, if I understand.
Because, hold on one second. So, because if they've all paid the fees, the same fees,
Right.
regardless of who paid them for the benefit of that student, and they didn't receive the services for which they paid, are they not in like commonality with each other?
No,
Or the same injury?
no, they have,
That's why I'm looking at that wrong.
they have an injury in fact, as they argue, for purposes of Article 3 standing. But if you look at the elements of a contract, they can say they have a contract because they entered into the registration agreement. The contract was breached because we didn't get to use the gym. But they can't prove the third element because they did not pay their fees and therefore have no loss.
You're saying that because of the way the class is defined, that causes the problem.
I think that's the heart of the problem. And I don't know what kind of time I have, but
You're at 8 minutes.
Okay.
So you're doing fine.
okay. So let me just quickly move over to the other issue, which is the voluntary payment defense. Now, this is a little more complicated because of the Sixth Circuit's decision that the 725.04 doesn't apply in any contract action. And of course, as we argue in our brief, it's hard to square that with the language that the legislature placed in that statute. The legislature, in enacting that statute, chose language indicating that abrogated voluntary payment defense in cases where there is no enforceable contract or payment is excused. And if this is simply...
The Gundel case?
Yes,
Gundel?
yes. And so you have to read that language out of the statute to get to that result, that it doesn't apply in any contract action, which of course is contrary to rules of statutory construction. If you accept the premise that the voluntary payment defense is still viable, unless the limited language of the statute applies, then you have an individualized situation, because Florida courts have repeatedly ruled, as have other courts, that students have to, or payers have to show that they raise some objection and indicate the alternatives and avenues that they pursued in order to follow up on that objection. And in this case, the record shows, the record testimony is that some students filed a request to have their fees adjusted because of COVID, and those requests were granted. and Miss Moore did not. So by definition, her claim is not typical of all the class members. And more importantly, once again, you have a situation where you have a defense that requires an individual examination of each class member, which is contrary to the premise of class certification. It violates the rule in a number of different ways. So I think the problem here, like I said, is that if you allow the class as certified to go forward, even if there is no way to determine who paid the student fees, no easy way anyway, you have a situation where USF is going to end up double paying people who were awarded scholarships, given money by the university. You have people who have no viable claim, who are going to get an unfair windfall, which is
Are
against.
you conceding that there is a certifiable class if it's defined differently?
I would have to take the position that I would want to see the language that's being used, and I would argue, because again, even if you look at the Adondo case that the court said, by certifying a class of all students and people who paid the fees for the students is overly broad and should not have been certified. So whether or not a class can be certified, it depends on how they state it.
But does that create a windfall to college if there's no certifiable class?
No, it just means there's no class action.
I'm sorry, that's what I meant to say. If there's no class action, that leaves each student to their individual abilities to bring suit, get recovery, what have you.
Correct.
As opposed to joining up with the other 39,000 that are.
Correct. And I take Your Honor's point about overlap, but I would submit there's probably not complete overlap, so we may be north of 50,000. But I agree. I think it restores, by overturning the class certification, it restores the USF its substantive due process right to defend itself by saying you have no damages you can prove, so your claim is not viable, and you didn't pursue any objection, you didn't file a fee adjustment request like many other people did, and therefore we have the right to a jury's individualized determination on the voluntary payment defense. So with that, I would respectfully request that Your Honors reverse the decision of the trial court granting class certification.
Okay.
Thank you.
5 minutes when we return.
Thank you.
May it please the court. My name is Howard Bushman. I represent the plaintiff, Valerie Moore, and a certified class of similarly situated students at the University of South Florida. As my colleague, Mr. McRae said, there are two basic arguments that are being made here today. First argument is that students who had a third party, such as a parent or had student loans, pay for their fees.
How about waiver?
I'm sorry?
How about waiver? You have students where the fees were waived.
They would not be class members.
Well,
Or they would have zero damages.
well, they're in your class.
Correct, and they would have zero damages, which is okay under the Sosa case. And the cases that Mr. McRae said where you want to include these third parties, every one of these cases, and I think this is where we agree, parents don't have standing. The third party payers don't have standing because they didn't sign the contract with the university. In the Arredondo case, they literally said that because the class includes parents and third party payers, it's too broad.
Well, according to your briefs, somebody's brief, about 75% of all students at USF are getting some sort of aid. And we don't know if that aid's going to pay these fees, but it probably has. So it seems like the majority of these students are not paying this. Well, somebody else is paying it.
Well, that's not true. You take
Well, I'm
Valerie.
just asking. I mean, you know.
There's no evidence in the record that USF allocated any type of student loan payment to a specific fee. As a matter of fact, if somebody like Valerie Moore took out student loans to pay for her tuition and her fees, which she did, which, you know, student loans are the worst kind of debt to take out because it's not dischargeable. But she's going to have to pay that eventually, irrespective if she got a student loan to pay her tuition now. So the fact that you have a third party come in and pay, that does not affect class standing in any way whatsoever. As a matter of fact, the Messner case that my colleague brought up literally says that when a parent pays for the...
I get all that. I still want to go to waiver. Waiver means you don't have to pay at all.
If a student went and got a waiver of these fees, then they did not pay for the fees. And then therefore, they would not either have damages for that particular semester, they wouldn't be able to recover for that particular semester, and be able to recover for the other semesters.
Ms. Moore got a waiver. Herself got a waiver.
Ms. Moore paid, as the judge Farfante noted in his order in paragraph 14, the undisputed evidence in the record shows that the plaintiff was charged and paid the student fees during the spring and summer semesters in 2020 for student services that were not provided. So if she had a waiver for another semester, that's...
Okay. She had 2 semesters, apparently a homeless waiver.
There was a waiver for one of the semesters, which is in USF's records. USF has testified at the evidentiary hearing that they're record keepers, that they're able to know everything about every particular student. And if there's a waiver in one particular semester, and she can recover for the other 2 semesters. That's an issue of damages. That's not an issue of standing, which is what we have here. Whether or not Ms. Moore, she was charged a fee during the class period, she paid that fee during the class period, and she has standing to represent class members who paid fees during the class period.
But can I go back to, you were talking about SOSA.
Yes.
So does SOSA stand for the fact that if you have no damages, you can still remain in the class?
Yes. Yes, you can have...
Versus varying damages. I mean, I understand the theory that the fact that individuals in the class have different damages doesn't wipe out their commonality.
Correct.
But no damages? I mean,
At the end of the day, I believe you could read SOSA to say that
I'm
you can
not
have...
reading it that way, but that's why I want to ask the question to you.
As I read it, varying damages means that ultimately you could have a verdict for a particular student that has a 0 damage number.
But if no one's been damaged, you're saying SOSA allows that person in the class, and it doesn't defeat the commonality of the class members?
No, it doesn't. No, it doesn't. Varying damages...
What about Mr. McCrae's argument that the way that the class is defined is all students enrolled at the University of South Florida who paid fees? In other words, to be a member of the class, you must have paid the fee, not anybody else, not waived. Not because of the rule, but because of the way the class was certified.
I think that's an incorrect reading of the way that the class has been defined. The way that the class
I'm
is...
just reading it off the court order.
Well, the issue is paid. So does that mean that a student had to literally go down to the offices at USF and hand them cash or a check?
I think the point is the language of the certification could have been different. And had it been, instead of saying students that paid, it should be students whose fees were paid, presumptively by somebody else. I think it's a linguistic issue. I'm not sure how big of an issue it is. You probably heard my question to Mr. McCrae, but that's the issue on the table.
I don't think it's an issue, and I think it's consistent with, Judge Morris, you said that the leading case was the little case. That was the class definition in the little case. And the same with the class definition in the Ninavaji case in the University of Delaware. And the Stoulis case for the Regents of the University of Minnesota. All of these were students who paid. And they distinguished themselves from the cases that were cited by Mr. McCrae in his brief as to all persons, which is the Evans versus Brigham Young case, which was defined as all persons, which would have included parents, which would have included student loan providers, which we all agree those entities wouldn't have standing to bring a breach of contract claim against the University of South Florida because they didn't enter into the contract with the university. So the people with standing are the students who entered into the contract and the students who paid either through their student loans or if their parents gave them money, or however it works, the university received funds for those fees, and therefore those students have standing, are in the class, and have damages.
So you're arguing that where it says who paid fees doesn't necessarily mean the one individual student, it could mean whoever.
Correct, correct. The student is deemed to have paid because the student is deemed to the one to have the obligation. If the student doesn't pay, the student gets sent to collections. If the student doesn't pay, the student gets de-enrolled. If the student doesn't pay, the student owes attorney's fees to the university when they file a collection proceeding. Not the parents, not the student loan providers. It's the student. So the language in the class definition of all students who paid means that it's all students where the university received money from them for these fees, which is every student in our class.
Can I shift gears?
Sure.
I'd like to talk about the superiority or manageability of the class as required by 1.220B. The appellant argues that Moore's case is decidedly different from other cases, and therefore proving her case isn't necessarily going to prove other cases. You want to address that?
Moore is exactly similarly situated as to every student. So to prove her case, which is the University of South Florida charged.
But maybe the issue here relates to the issue we've been talking about. Because in Moore's case, she got scholarships and waivers. She didn't pay it herself. In other cases, there were parents who paid. And there are other cases where students paid. And maybe the issue here is that the proof isn't the same.
I think what Your Honor might be referring to is the CARES Act funding that Ms. Moore received, which wasn't a scholarship, but the Ninavaji court deals with that head on. Says it doesn't matter if somebody received CARES Act funding. The University of South Florida, if you look at the detail that they provide, the account detail for term that they provide, has all of their tuition, all of her fees, and on the bottom it says student loans, $7,000. CARES Act funding, $1,000. It doesn't sit there and say, we're paying the fees down. Ms. Moore has to pay back for at least one semester, over $7,000 in student loans that covered her fees. And I am a father of a student at the University of Florida, and I do know that when you get an outside scholarship, such as the
Bright Future.
The Bright Future Scholarship, it doesn't cover fees. Never does. It covers tuition. And this is not a tuition case. So Ms. Moore will prove that the University of South Florida charged her and she paid for fees, shut down its campuses and did not provide her the services to which those fees were entitling her to. And she will do that for every class member. And Judge Farfante hit that head on when he says that the common issues at a trial in this case, and I know Judge Morris, you're familiar with common issue trials. The common issues in this case will be whether or not will include the same evidence, such as the terms of the registration agreement, information on the account details for terms, which specify the exact fees charged to students and the amounts charged and paid by students, the amount of fees collected from the students during the semesters in 2020 and 2021, and if those fees were spent during the semesters. These are all common issues that will be tried, irrespective of the individuals. In addition, the common defenses will be tried too. Sovereign immunity, voluntary payment, those all are common issues that will be tried for everybody, apply to Ms. Moore and apply to every student at the University of South Florida. In addition, Judge Black, you said it earlier. If you don't certify the class, we're going to have 40,000 students filing individual lawsuits. This is the quintessential case that would be superiorly tried as a class action. Everybody knows the fees. They're all uniform, same amount. Very few of them compared to some of the other schools that were cited in some of the briefs. Some of those schools charge 400 fees as opposed to just the few that we have here. Small amounts. No student is going to file a case, breach of contract case, that doesn't have an attorney fee provision for $20 or $100 or $500. They're just not going to do it. The only way to do it, the only superior way to do it, is through a class action and through the class action device. I can briefly touch on the voluntary payment, Doctor. I don't know how much time.
No, that's a good idea. Why don't you go to that?
Okay. Well, as my colleague, Mr. McCrae, stated, the voluntary payment defense is not available in contract actions. That's the Avatar Properties case. In addition, the doctrine only applies when the payments are voluntary. It's not when the potential consequences of non-payment are sufficiently severe so as to leave little or no choice but to tender payment. That's the City of Key West case that's in our brief. And that's what we have here. If you don't pay, you're kicked out. If you don't pay, we send you to collections. Judge Casanueva, in his opinion, affirming the denial of the motion to dismiss, sort of telegraphed this argument when he wrote that USF's policies must be examined to determine if USF promised to provide any specific services in exchange for student fees. That's not really voluntary payment, but in footnote 3 that he put right under that, he said, those policies provided that Ms. Moore was also required to pay the attorney's fees of USF in the event she defaulted on her payment. You could not have a starker example of a bargaining position that is so imbalanced that the University of South Florida has with its students. These students want an education, they want to go to school, and if they don't pay, they're kicked out. It's without, well, I probably should have led with this, but the standard of review in a class certification is the abuse of discretion. And Judge Morris, you stated in oral argument in the Concert Plantation versus Dorso case that this means that this court would need to find that no reasonable judge would have done what Judge Farfante has done in certifying this class. No reasonable judge would do the same thing. And given the record, there's simply no way USF can meet this standard. In addition, SOSA says that if you have a doubt as to class certification,
Resolve it in favor of certifying.
resolve it in favor of certifying, especially when we haven't had merits discovery, which we haven't. It's been stayed until resolution of the class certification. Unless your honors have any further questions, I'll rest on our briefs. We ask that you affirm the trial court's decision certifying this class, and thank you for your time and consideration.
Thank you very much. McCrae, you have 5 minutes.
Thank you, sir. May it please the court. As we indicated in our initial brief, the standard of review, which was enunciated by the Sosa court, is abuse of discretion. But the court went on to say legal conclusions underlying a class certification decision are reviewed de novo. The appellee agreed with the standard of review that we cited. Therefore, an abuse of discretion occurs when the trial court commits a legal error. And we contend, in this case, there were several legal conclusions that were in error and are subject to de novo review, including the court's order, page 7. It's not necessary to know who paid student fees to ascertain class membership, which is directly at odds with the language of the certification. Secondly, whether certification of the class contained members who have no damages and therefore have no viable claims is lawful. And third, whether USF's voluntary payment defense can be applied to the case as a whole. The concept of doubt being resolved in favor of class certification is true, but that principle doesn't stretch far enough to apply to where class certification is founded on erroneous legal conclusions. I wanted to point out that I take direct odds with the statement that somehow SOSA supports the conclusion that a class can be certified with people who have no damages, particularly in a situation where damages are an essential element of liability. There is no Florida court that holds that. Essentially, what Florida courts recognize is that where there are varying damages, that should not be an obstacle to class certification because it can be sorted out after liability and common issues are determined. And this is not, voluntary payment is not a common issue, as we recited. Coercion is not unlawful if somebody does what they have a legal right to do, such as refuse services where no payment has been made. I would go back to the 10th Circuit in Evans, which was not swayed apparently by the concern that there would be tens of thousands of individual students suing from Brigham Young University. This case is just like Evans. The court in 10th Circuit found that the class involved uncertainable class members. In that case, it was third-party payers. In this case, we have uncertainable class members because we don't know whether or not students paid fees or someone else paid the fees. So at the end of the day, we're looking at an order that certified a class of students who paid. We don't know who they are, and we certainly believe that some of these students don't have damages, and therefore USF is.
But those that don't have damages, are they in the waiver category?
Well, Section 1009, which was part of the hardship waiver, has 7 different waivers for students at state universities. So yeah, there are going to be a lot of waiver people. There may be other people who filed and got a fee adjustment waiver by USF.
But that's something that can be identified, those with waivers and those with not, right?
It's just back to whether or not it's administratively feasible, and there's been no demonstration that somehow somebody can engineer some software that would pluck out of tens of thousands of account details.
You're saying like in their account, I think it's Oasis, right? There's something that there's nothing that shows whether or not there was a waiver given or how the fee was paid.
On an account detail by account detail basis, I'm saying there's no evidence in the record that somehow that can be spit out of a computer using some software. The testimony is that there has.
Other than, you're saying other than looking at each individual tens of
Correct.
thousands of individuals.
Exactly. And then we say beyond that, even in the information in the account details is not complete when it comes to employers, parents, grandparents, of whom I'm proud.
Okay, but that's the third party issue.
Yes.
We're talking about waiver versus non-waiver students.
Correct. I'm saying that even if you assumed, which I don't believe the account details showed the payors in all instances, that would be something that could be readily ascertained. It would involve individualized review of tens of thousands of account details. I feel like I'm over my time.
You're at 10 seconds.
Oh, okay. Thank you for your time and your attention.
This is a very interesting case, and I know all of you worked hard on it. We appreciate your efforts to help us figure it out.